In this case, an Australian citizen successfully appealed to the United Nations Human Rights Committee, arguing that Australia had violated her human rights by preventing her from applying for a divorce. What happened is that an Australian woman, referred to by the letter C, was in a relationship with another woman known as A. They had a daughter in 2001. In 2004, Canada changed its laws to provide marriage equality for same-sex couples. They went to Canada and got married. Unfortunately, same-sex relationships can be just as messy as straight relationships. C and A separated just a few months after they married. C continued to have parental responsibility and A ceased to be involved at all in their daughter's life. For a number of reasons, personal, professional and legal, C wanted to dissolve her marriage with A. But at the time in Australia, same-sex marriage was not lawful, and government policy was that same-sex divorce was also not lawful. This was a bit of an odd position for them to take because there are other types of marriage which were unlawful in Australia, where the parties still could access divorce. So, for instance, if parties contracted a polygamous marriage overseas, then a person leaving that marriage could obtain a divorce in Australia. Similarly, a person who had married at a younger age than was lawful in Australia could obtain a divorce in Australia. Why treat same-sex divorces differently? The Human Rights Committee said, the committee notes that Australia has failed to provide any explanation of why its stated reason for providing divorce proceedings for unrecognised foreign polygamous marriages does not apply equally to unrecognised foreign same-sex marriages. In the absence of more convincing explanations from Australia, the committee considers that the differentiation of treatment based on the author's sexual orientation to which she is subjected regarding access to divorce proceedings is not based on reasonable and objective criteria and therefore constitutes discrimination. The committee resolved that Australia must extend to same-sex couples the right to seek a divorce. C had made her application to the United Nations in 2012. It took them until March 2017 to hand down a judgment. Later that year, Australians voted to allow full marriage equality, which included the right to seek a divorce. So we will never know how the government would otherwise have reacted to the Human Rights Committee's findings.